Good day, everyone. So I'm here today to give you a lecture on our CLEP training program, particularly Module 1. This is actually the second part of Module 1, Knowledge, Introduction, and General Information on the Revised Rule 138A. The first part was given by Attorney Rigor Pascual, and I will be giving the other salient features of Rule 138A. So the coverage of my lecture will only deal with the following topics: eligibility requirements, Level 1 and 2 certifications, practice areas, supervising lawyer, sanctions, and the effectivity of Rule 138-A. So we begin now with the eligibility requirements under Section 3 of the Revised Law Student Practice Rule. So under Section 3 of the Revised Law Student Practice Rule, it is provided that no law student shall be permitted to engage in any of the activities under the Clinical Legal Education Program of law schools unless the law student has applied for and secured the following certifications. So it means that the law student practitioners now, they cannot just engage in the practice areas provided under the rules without complying with these requirements. These eligibility requirements are actually composed of the academic requirements and the documentary requirements. So we proceed now with the first requirement. For Level 1 certification, it is available for law students who have successfully completed their first year law course, and or for Level 2 certification, these are available for law students who are currently enrolled for the second semester of their third year law courses, provided, however, that where a student fails to complete all their third year law courses, the Level 2 certifications should be deemed automatically revoked. So under the Revised Law Student Practice Rule, we now have two types of certifications, the Level 1 certification and the Level 2 certification. The purpose for which is to have an increase in the number of law student practitioners. Unlike before, when we only allow fourth-year law students to engage in the limited practice of law, now second-year law students, third-year law students, and fourth-year law students may now engage in the limited practice of law. The second purpose for providing two kinds of certification is so that our law student practitioners will be more efficient and more effective in engaging in the practice areas because they will have a substantial knowledge of the law which is required as part of the academic requirements for Level 1 and Level 2 certification. So for Level 1 certification, as I said earlier, it is available for law students who have successfully completed their first year law course. Completed means that the law students must have passed all their first year law courses. And then for Level 2 certification, these are available for law students who are currently enrolled for the second semester. So the Level 2 certification is available for second year law students, third year, and fourth year law students. However, if the Level 2 certification will be applied by third year's law students who are currently enrolled in the second semester of their third year law courses, there is a requirement that they should pass the second semester subjects. Otherwise, the certification that will be issued to them will be considered revoked. I also wish to emphasize that the certification shall be valid until the student has completed the required number of courses in the Clinical Legal Education Program to complete the law degree, unless sooner revoked for grounds stated therein. So it depends actually on the CLEP course that will be provided by the school. I think this will be better explained by the representative from the LEB because it will be them who will provide you with guidance on what are the type of CLEP courses that will be integrated into your curriculum. So for example, if the CLEP course is a 2-unit course and it will require 18 hours to complete the 2-unit course or 1 unit of that course, then the certification will be valid for the entire 18 hours until the student is able to complete the required number of hours necessary to pass the CLEP course. Another matter that I wish to emphasize is that a Level 1 certification is not a prerequisite to a Level 2 certification, meaning the school, for example, or the student, for example, may apply only for a Level 1 certification until he or she completes the entire CLEP course necessary to complete the curriculum. So, The law school, maybe perhaps for the entire duration of the school year, may only offer level 1 or may only apply for a level 1 certification, or may opt only to apply for a level 2 certification, or they may apply for both types of certification. So a level 1 certification is not necessary for the law school or for the law students to apply for a level 2 certification. So if the law school or the law students are only able to engage in practice areas that will cover only level 1 certification, then the law school may only apply for a level 1 certification. But of course, it would be better if the school can also apply for a level 2 certification, because the level 2 certification allows the law students to engage in a wider variety of practice areas, such as appearances in court, filing of pleadings, and certain activities that will allow them to appear before appellate courts. Insofar as the application for a level 1 certification is concerned, we have provided here a process map, which is also attached to your copy of the law student practice rule, or even in the annotations to the law student practice rule. So how do you apply for a level 1 or a level 2 certification? So these will now cover the documentary requirements and the procedure for the issuance of the level 1 and level 2 certification. So for both certifications, actually, the law student must submit two things: 3 copies of the application form duly accomplished and under oath, and proof of payment of the necessary legal and filing fees. So this application must be submitted by the law student to the law school where he or she is enrolled in. And then the law school, through its dean or its authorized representative, will now collate the documents submitted by the law student and then make an endorsement also under oath, stating therein that the law student has completed the law subjects required for the certification being applied for. So if the law student is applying for a level 1 certification, then the application form should be accompanied by an endorsement stating that the law student has completed or has passed all the first-year law courses. And if the certification being applied for is a level 2 certification, then the endorsement must be accompanied, or the document submitted by the law student must be accompanied by an endorsement from the law school that the student has completed first year, second year, and third year law subjects, or if the student is enrolled in the second semester of his or her third year law courses, then that he is enrolled in such courses and that he has completed the same or passed the same. Otherwise, the certification eventually will be revoked. And then the endorsement should also contain a statement that the dean or the authorized representative knows that the student is enrolled in the clinical legal education course. So, hindi po pwedeng mag-apply yung mga law student na hindi naman enrolled sa CLEP course. So, kailangan po both enrollment and the academic requirements must be complied with by the law student before he or she can be endorsed by the law school for the application of a level 1 or a level 2 certification. And lastly, the endorsement should also contain a statement that the student possesses good moral character. Okay. The law student will now have to forward these documents, the ones submitted by the law student and the endorsement by the law school through the dean or the authorized representative, to the executive judge of the regional trial court having jurisdiction over the territory where the law school is located for the evaluation of the executive judge. So, for level 1 certification, it will be the executive judge of the regional trial court where the law school is located who will approve the application for level 1 certification. So, for example, the school is located in Quezon City. Then the regional trial court, the executive judge of the regional trial court of Quezon City should be the one who will receive the documents submitted by the law student as well as the endorsement made by the law school. It will be the executive judge of the regional trial court who will approve the application for the level 1 certification. And then once the executive judge approves the certification, then the executive judge shall notify the law school of such approval of the certification and shall accordingly set a schedule for the oath-taking of the law student whose applications has been approved. Para po siyang yung practice po natin for the issuance of a notarial commission. So magkakaroon po ng oath-taking yung law students natin. Under Section 8 of the Revised Law Student Practice Rule, there is a law student practitioner's oath. Ito po yung panunumpa or yung oath na sasabihin po ng law student practitioners natin who has been issued a certification during the oath-taking before the executive judge. And then for level 2 certification, although the documentary requirements will be submitted to the executive judge of the regional trial court, having jurisdiction of the territory where the law school is located, the only function of the executive judge is to recommend the approval of the certification to the office of the court administrator. It will be the office of the court administrator who will approve the certification, the level 2 certifications. The office of the court administrator may delegate the approval of the applications for level 2 certifications to the deputy court administrations to facilitate yung faster approval of the certification. So we have 3 DCAs po for Luzon, Visayas, and Mindanao. The same din po if the DCA or our court administrator approves the applications for level 2 certifications, then the DCA or our OCA will notify the executive judge of such approval, and then the executive judge will notify the law schools of the approval of the level 2 certifications and accordingly set the oath-taking of the law student practitioners. So that is the process map or the procedure for the issuance of the level 2 certification. Dahil nga po, we are currently in the middle of a pandemic, so this circular was issued to facilitate po applications or submissions of applications for the issuance of level 1 and level 2 certifications. Same lang din naman po yung procedures niya, it's just that dahil nga po limited yung mobility natin due to the pandemic, the submission of the application forms now with the endorsement of the law schools may be made either personally, by private courier, or email to the executive judge. So, in-incorporate po natin ngayon muna yung electronic means and other means of submissions just to give the law schools an opportunity to submit their certifications to the executive judge para ma-process po yung applications for certifications even during this pandemic. So that is the first step po. And then after that, the payment of filing fees may be made through the Office of the Clerk of Court of the RTC or any branch po ng Land Bank na malapit po siguro or malapit sa court or malapit po dun sa school. I think you can inquire naman po with the OCC as to the account number of the land bank para kung saan po i-deposit yung payment for the payment of the filing fees. That's both for level 1 and level 2 certifications. As I explained earlier, magkakaroon lang ng variation with respect to the succeeding steps insofar as level 1 and level 2 certifications are concerned due to the fact that magkaiba yung approving authority for level 1 and level 2 certifications. So again, just to emphasize, for level 1 certification, it will be the executive judge of the regional trial court having jurisdiction over the territory where the law school is located who will evaluate and approve the applications for level 1 certifications. And thereafter, the executive judge shall notify the law school of the approval and schedule the oath-taking. And then after that, the executive judge shall perform the oath-taking. Dahil nga po meron tayong pandemic, so nilagyan din po ng OCA ng option na the oath-taking can be done via video conferencing. So, nasa executive judge na rin po yan kung hindi naman po masyadong madami yung mag-oath na mga law students, he or she can opt to conduct the oath-taking via video conferencing or in court po, provided lang po na mag-comply tayo with the social distancing requirements. as required by the applicable IATF rules and the other safety protocols po in view of the pandemic. So after the oath-taking of the law student practitioners, then the executive judge will now issue the level 1 certification. So yung level 1 certification po, pwede rin pong ipadala by email or pwede rin pong ipadala na yung hard copies dun sa law schools. And then that certification po will be now the proof po that the law student may now engage in the practice areas allowed under a level 1 certification. So again, for level 2 certification, just to reiterate my earlier lecture, after payment of the filing fees either with the Office of the Clerk of Court of the RTC or through any branch of the Land Bank, then the executive judge shall evaluate and recommend only the approval of the applications to the Office of the Court Administrator through the DCAs or through the ACAS, and then notify the law school if the requirements are incomplete or complete. So kung incomplete po yan, pwede pong ipabalik po ng DCA through the EJ yung applications dun sa law schools para ma-notify yung law schools what are the incomplete or lacking requirements so that the law school can resubmit the applications to the executive judge for re-evaluation. If the documents, on the other hand, are complete and the EJ is satisfied that there is merit in the application, then the executive judge shall recommend to the OCA through the DCAs or the ACAS the approval of such recommendation. And then once the DCA or the assistant court administrators approve the applications for the level 2 certification, then they shall forward the same to the executive judge. And then again, the executive judge will have to notify the law school. Pwede rin, yung pag-notify po ng executive judge dun sa law school can be done personally also by private courier, by email, by phone call. Dahil nga po sa pandemic natin, we will allow, I think the OCA Circular's intent is to allow all possible means of communication just to notify the law schools of the approval or disapproval or notice of any incomplete requirements with regard to the application. The executive judge shall notify the law school of the approval of the application, schedule the oath-taking, and then perform the oath-taking. Again, just to emphasize, the level 2 certifications will be issued by the OCA through the DCA or the assistant court administrators, and then such certification will be valid until the law student is able to comply with the requirements of the CLEP course as provided by the or as included by the law school in their respective curriculum. So now that the law student has been issued a level 1 or level 2 certification, he may now engage in any of the practice areas as provided under Section 4 of the revised law student practice rule. But before I explain to you what these practice areas are, I would like to show you a short video of the clinical legal education program in the US, just to give you an idea of how this clinical legal education program will be implemented. And you will see in this video that the law students have been engaged while they are in law school.
Even starting as a first-year law student, you can stand for the client. You can literally be the primary advocate at the hearing, and it's always a student who's a primary advocate at the hearing.
I just got back from Dongguan in southern China, where I was working on a Harvard negotiation, mediation, and clinical program project. It was a tremendous project management experience, and it's just fun to go to China.
In many ways, the clinical programs at the law school allow us to get more litigation experience than you would get, after 5 years at a firm, because you're assisting people. But here, we're handling the case.
What do we do when the banks attack? Stand up, fight back! What do we do when the banks attack? Stand up, fight back! What do we do when the banks attack?
No One Leaves is an organization that's making sure that people aren't going to be living in a home one day and homeless the next day because of the foreclosure crisis.
The students really the driving force behind this, and I can't say that we have the solution to it, but we are far ahead of any other city in the country, and a big part of that is the work that the students at Harvard have come up with and have implemented.
Just to be able to say to someone like, hi, I'm Julia. I am here specifically because I want to, give you the help that you need to get through this. That's the whole idea behind No One Leaves.
So essentially we came up with a model to combat this problem of land loss of African Americans in the South. But the model that we came up with is actually in use right now. It's being used in North Carolina and adapted to be used in other states around the South.
I've written some motions that literally the ADA will read and sign off on, and she'll sign and it'll get filed with the court, and that's my work product, and that's really exciting.
Often opposing counsel like to talk down to students about this is your school project. And so then when we get to take them into trial, it's like, well, welcome to my school project.
I really love what I do, and I'm really passionate about it, but I'm a baker. I know nothing about law.
I'm really interested in helping entrepreneurs and small business, and so it's motivating for me. And it's kind of an ideal client for us to have because we like to see people that are passionate about what they do.
One thing the students learn is to view things through a transactional lens. In the business area, for instance, students will work on forming companies, counseling clients,
Permitting issues, licensing issues, negotiating with the opposing counsel. To help out someone who's a new small business owner, accomplishing her dream, I think it's a pretty cool thing.
I would recommend a clinical to anyone. I just think it gives your legal education so much meaning. And I think it's great you recognize the kind of skills you have and the things you can do with them.
Okay, so we now go to the practice areas under Section 4 of the Revised Law Student Practice Rule. These practice areas take into consideration the courses that had been completed by the law student practitioner. So these practice areas are also divided into or classified into two. Practice areas for Level 1 certification and practice areas for Level 2 certification. So under Level 1 certification, a law student may engage in any of the following practice areas: to interview prospective clients, give legal advice to the client, negotiate for and on behalf of the client, draft legal documents such as affidavits, compromise agreements, contracts, demand letter, position paper, and the like, represent eligible parties before quasi-judicial or administrative bodies, provide public legal orientation, and assist in public interest advocacies for policy formulation and implementation. So, a law student who has been issued a Level 1 certification may engage in any of these practice areas. Any or all of these practice areas if the law student practitioner can engage in all of these practice areas. So, just to give you an example of what yung specific practice areas under Level 1 certification. So, a law student may engage in legal consultation or lectures on katarungang pambarangay law, basic labor standards, small claims cases or ejectment, anti-cyberbullying law, VAUSI, child abuse, ordinances, the SOGI bill or prison conditions and management. The law student or the law students issued a Level 1 certification may go out into barangays, schools, or offices, and then they may conduct legal consultation or lectures on certain laws, whether these laws are already effective, or they may explain to them what are the penalties under these laws, requirements under this law, and so on and so forth. Law student who is issued a Level 1 certification may also provide legal assistance to LGUs regarding ordinances. Like for example, in the city of Manila, the ordinances are not codified. So the law students, through their CLEP or through their clinical legal education program, may coordinate with the local government unit of Manila to come up with a codified book or a codified ordinance for the City of Manila, and that will be allowed under a Level 1 certification. And then, after that, after helping the LGU codify their ordinances, then perhaps they may also go out into the community or into certain barangays to explain these ordinances, how these ordinances are violated, the penalties, and the fines corresponding to the violation of these ordinances. And then, for Level 2 certification, the Level 2 certification, because it is already allowed or it is already given to law students who have completed or successfully completed first year, second year, and third year law courses, then the practice areas are more expansive. So under Level 2 certification, a law student practitioner may engage in any of the activities under a Level 1 certification that I mentioned earlier. They may assist in the taking of depositions and or preparing judicial affidavits of the witnesses, appear in behalf of the client at any stage of the proceedings or trial before any court, quasi-judicial or administrative body, and in criminal cases, subject to the provisions of Section 5, Rule 110 of the Rules of Court, to appear on behalf of a government agency in the prosecution of criminal actions, and in appeal cases to prepare the pleading required in the case. Just to emphasize also, whether a Level 1 certification or a Level 2 certification is issued to the law student practitioner, these practice areas may only be exercised by the law student practitioner under the direct supervision of a supervising lawyer. So, yung mga law students po natin, hindi rin sila pwedeng basta-basta na lang po mag-engage dun sa practice areas na to. Kailangan pa rin po ng guidance and ng direction ng mga supervising lawyers. As I said earlier, a Level 2 certification allows a law student practitioner to engage in more expansive or a more variety or types of practice areas than a Level 1 certification. So, under a Level 2 certification, a law student practitioner may in fact engage in appellate practice under the supervision of a supervising lawyer. So that is appearances or filing of pleadings before the Court of Appeals, the CTA, the Sandigan Bayan, and even the Supreme Court. But of course, subject to the limitation on jurisdiction. And then appearance also before the appellate bodies is subject to leave of court, mainly because also of the concern on jurisdiction. So what is that concern on jurisdiction? So under the revised law student practice rule, a law student practitioner shall only be allowed to practice within the region of the executive judge who issued the certification. So for example, a law student practitioner from UP Diliman who was issued a certification by the executive judge of the RTC of Quezon City, kasi it is the executive judge of the RTC of Quezon City who has jurisdiction where the law school is located, then the law students or the law student practitioners from UP Diliman may only practice within the National Capital Judicial Region. So, if in case there is a case that is outside of that jurisdiction, then there should be prior approval or leave of court that must be applied for by the law student practitioner through the assistance or through the guidance of the supervising lawyer to the appropriate court para payagan po silang mag-practice dun sa area na yon. Or the application must be made to the Supreme Court to allow them to practice outside of the territorial jurisdiction. With regard to the supervising lawyer under Section 10 of the Law Student Practice Rule, I would just like to add a few points, but this portion was already discussed by Attorney Ricor Pascual in Part A of Module 1. But just to emphasize, a supervising lawyer must be a member of the bar in good standing, and he must be able to exercise competent supervision over the law student practitioners, and that the supervising lawyer must appear in court with the law student practitioner in 3 instances. Number 1, when it is required by the rules, upon order of the court, or when he deems it necessary. So what do I mean by competent supervision? It means that, for example, if there are 20 law student practitioners that are issued a level 1 or a level 2 certification, then the supervising lawyer must be able to ensure that he has the capacity, the means, and the time, the resources to supervise all the 20 law student practitioners. Then otherwise, if he cannot, he must take in a smaller number of law student practitioners so that he can effectively supervise them. Another aspect of competency is that, for example, he must be able to, the practice area being engaged to by the law student practitioner is not an area of expertise of the supervising lawyer, then perhaps maybe another supervising lawyer whose area of expertise is more compatible with that chosen by the law student practitioner should supervise that law student practitioner to effectively and efficiently give that law student practitioner the guidance that he or she needs in engaging in those practice areas. But hindi naman po natin sinasabi na hindi competent yung mga lawyers natin. It's just that we just want our law student practitioners to give or to get the best training they can get from the best guidance they can get from their supervising lawyers while they embark on these practice areas. Kasi kung hindi naman po yan yung area talaga nila or they have no knowledge, they have little experience on that particular case or particular issue, particular legal area, then hindi rin po ganun matututo yung mga law student practitioners natin. So, in that regard, I will now proceed with the sanctions under Section 13 of the Revised Law Student Practice Rule. The sanctions are provided in the rule basically because our law student practitioners took an oath. Diba? Yung oath nila, if you will read the oath that will be taken by the law student practitioners, parang similar siya dun sa lawyer's oath. So there is a commitment on their part that they will engage in the practice areas as lawyers, although in a limited sense. So if they will engage in an authorized practice of law, then they will be sanctioned accordingly. So ano ba yung unauthorized practice of law by a certified law student practitioner? So that is engaging in any of the acts provided in Section 4 of the rule without the necessary certification or without the consent and supervision of the supervising lawyers, making false representations in the application for certification. Like for example, sinabi niya na na-complete na niya yung mga first year law courses niya pero hindi pa. Pero meron naman tayong protection dyan kasi there's an endorsement under oath by the law school that the law student was able to complete the required subjects to be able to apply for a level 1 or level 2 certification. Or for example, may nisa-present niya doon na naka-enroll siya sa CLEP course pero hindi naman talaga, or na meron pa siyang subjects na hindi natitake, pero sinabi niya na tinitake niya. Pero meron pa rin mga safety protocols after that, pero just the same, baka meron kasing mga lumusot. So that will be considered as an authorized practice of law by a law student practitioner. And then another example is using an expired certification to engage in the limited practice of law under this rule. Like for example, natapos na niya yung CLEP course niya kasi 'di ba the validity of the certification is only up to the time that the law student practitioner is able to complete the required number of units or hours under the CLEP course provided by the school. So if after that ginagamit pa rin niya yung certification niya to engage in the limited practice of law, then that is considered as an authorized practice of law and will be given appropriate sanctions. Then another one is rendering legal services outside the scope of the practice areas allowed under Section 4 of this rule. Like for example, level 1 certification lang ang na-issue dun sa law student practitioner pero nag-engage siya dun sa practice areas na under level 2 certification. Then that will be considered as an authorized practice of law also. And then asking for or receiving payment or compensation for services under the Clinical Legal Education Program as provided in this rule. So, services to be rendered by law student practitioners under the Clinical Legal Education Program should always be pro bono. Wala pong bayad yun, ha? But the law student practitioners may collect fees for yung mga docket fees, filing fees, TSN, and fees. But for the services itself, there should be no payment for the services to be rendered by the law student practitioners. And then such other analogous circumstances. So these unauthorized practice of law shall be a ground for the revocation of the law student practitioner certification and or disqualification of a law student from taking the bar examination for a period to be determined by the Supreme Court. So medyo mabigat po yung penalty. Kasi baka dun, sa pag-engage ninyo dun sa unauthorized practice of law, makikita na kaagad na, are you really deserving to be really deserving to be a lawyer? Kasi kung dito pa nga lang, nag-engage na kayo in unauthorized practice of law, what more pa kung maging lawyer na kayo? So at medyo mabigat din yung penalty for engaging in these activities. And then, of course, aside from engaging in unauthorized practice of law, any violation also of the Code of Professional Responsibility shall subject the supervising lawyer, the clinical legal education program head, and or the law school dean to disciplinary action as the circumstances may warrant. So we now proceed to the last part of the lecture, which is the effectivity of the law student practice rule as provided under section 14. So, start of academic year 2020 to 2021. So, nag-start na po siya this year following its publication in 2 newspapers of general circulation. So, actually, ngayon po pwede na kayong mag-apply for level 1 and level 2 certifications para po yung law students po ninyo na qualified, makapag-engage na po siya into the practice areas. In fact, there are already law schools who have applied for level 1 or level 2 or both types of certifications using OCA Circular 160-2020. The effectivity also of the rule shall be a requirement for applicants commencing the 2023 bar examinations. So, para lang po malinaw tayo, the effectivity of this rule is prospective po in nature. So it will not cover those law students who have obtained their law degrees prior to the effectivity of this rule, and then graduating students for academic year 2019 to 2020, and those who will take the bar examinations before 2023. So here are 4 of the common questions asked with regard to the effectivity of the law student practice rule. First is, for example, A graduated in 2022 but failed to take the 2022 bar examinations due to meritorious reasons. Is he required to take the clinical legal education program before the 2023 bar examinations? The answer is no. Kasi po, hindi naman po siya nag-graduate na po siya in 2022 pa. Okay? Next question is, A was an incoming third-year student in school year 2020 to 2021. When he graduates in 2022, is he required to have the clinical legal education program? Again, the answer is no. And then, another question is, A graduated in 2023. Is he required to take the clinical legal education program before taking the 2023 bar examinations? The answer is yes. So, para lang po malinaw, for purposes of taking the bar examinations in 2023, there are 2 periods to be considered. The first one is the year of graduation, and the second one is the year when the student would take the bar. So, if if the law student graduates before 2023, CLEP is not a requirement. If he graduates in 2023 or afterwards, and he will take the bar examinations in 2023 or subsequent bar examinations, then the clinical legal education program is a requirement to take the bar. Okay po. So if you have further questions po with regard to this presentation, you may send them through this LMS, and then we will try to answer it and then give you our responses after this lecture. So thank you very much.